Thank you everybody for joining us. We're ready for another session today. And last but not least, in one of my favorite sessions, you will find throughout today that I picked the perfect duo for this session, and you're going to love this. So, I am Traci Kaas. I'm a settlement planner, certified financial transitionist, and a financial advisor, author of What You Can Expect When Expecting a Settlement. This is something that I wrote and published actually a full year ago. It never got a release because of COVID, but it is there for you and for your claimants and for your plaintiffs. So as you're working with the clients and helping them through the process, this is going to help you as well as the clients. Also, during COVID downtime, did a reference guide for my attorney friends and clients. So this is your quick reference to there's a couple references on the minors compromises and such we're going to talk about today, but also how to protect you from any malpractice or anything like that. Do I or don't I? Do I settle the case? What are the red flags? This is about that too. So anyway, enough about me. Today is how to get the money into your trust account as soon as possible. How can we avoid the stoppers and the road speed bumps as we're going along, and what can we do to get ahead of things? And so this seminar is going to work perfect for the attorney who's been practicing for a very long time and just needs a refresher, but also fantastic for people that are just kind of getting into starting their law firms and making life a lot smoother. One of the things that I've realized in my 16 years of doing this is when you become an attorney in a firm that walks into the court and the judge knows your name is on it, they feel so much more relieved because you have a consistent record of not having errors during your compromises, that your paperwork is the T's are crossed, the I's are dotted, and they're very, very comfortable. I have found that over and over, and I've actually received cases from judges that have referred to me. And that's the kind of client or attorney that you would like to be when you're in front of the judge as well. So let me do some introductions. First, I'm going to introduce Molly. She's a partner at Greenberg and Wheeler, and she is a CAOC Attorney of the Year. Go, Molly. Active in a million TLAs. Just go, go, go. Everybody knows Molly. But one of the reasons that I think that she's fantastic even for this is she's a mentor. A lot of us don't spend the time giving back, and I think that that's super important for everybody. And Molly works a lot with the Pepperdine to mentor people and help people. So just her ability and willing to educate and train is just outstanding. And she's a kick butt golfer too. Welcome, Molly.
Hello, thanks for having me.
Of course. And Taylor, we have Taylor as well, another partner at the Greenberg and Wheeler. I am so lucky and privileged to have you guys. Taylor's been a Street Fighter of the Year, and talk about kick butt, right? Taylor's just out there. Street Fighter of the Year of CAOC, and she's been on the top super lawyers and rising star, top 50, top 100, top everything, as well as active member in a million of the different TLAs across the country within the state, and especially working with CALA. And again, another person who really, really gives back, especially on the education committee and putting together different seminars that really is all about education. I couldn't be more honored to have these two. Taylor, also above anything, is really into trauma advocacy. And that speaks really near and dear to my heart, being a sudden money person, making sure we're connecting the emotional side and the technical side. Taylor also makes sure that the clients are doing for their well-being as well as obtaining great results. So welcome, Taylor.
Thank you. Thanks for having us.
Of course. Taylor, if you want to kick us off today, I think we have a lot of material to go over. And so I just want to tell the viewers that, we have a PowerPoint, but above the PowerPoint, if you want to reach out to us and you want the PowerPoint sent to you, we can do that. But feel free to reach out to any of the three of us. I think all of us on this panel love educating and helping people. So, feel free, but we've got a lot of material. So Taylor, if you want to kick us off.
Sure. So I think what's really important when you're getting to the point where you're approaching a mediation and you're getting close to settlement is you need to have conversations with your clients. before you're showing up to the mediation. One of the biggest things, and since we're really focusing on kind of like minors comps or, people with disability, typically there's some kind of parent that you're dealing with or guardian. And a lot of times, even though you've been going down the case, for over a year now, most likely, and you've explained to them that they don't get any money, that the money is going to, their child or, whoever it may be, they forget that. And so when you're showing up to the mediation, they're going, well, where's my money? And so I think it's really important that you're having these conversations with them prior to the mediation so that they understand how this is going to affect not only the person that's been injured, but also them. And the parents will tell you, like, this was traumatic for me. For example, like in a case where you've got a kid that was sexually assaulted, well, the parents are traumatized by that as well. Or a kid, that maybe is now quadriplegic and the parents are going, well, I take care of, like, I bathe my child, I wash my child, I have to buy them special, apparatuses for things that they do. And so this is why I always think that you should bring somebody in like Traci, who can sit down and speak with the clients prior to the mediation to talk about the various ways of how you can place this money and how then the parents or the guardian can access the money as well. So there's a ton of different things, which I think as we get further into the presentation, we'll talk about, but it's just important to let the parents know of, look, like when, Johnny wants to go to a science camp, we can pull money out for that. When you need to buy, Johnny some kind of special equipment for, what, he needs, we can access that money. So while the money is not technically coming to you, it is money that can be used for all things for, your child, especially even with buying a home. Those are things that can be used as well. So it's just important that you have those conversations prior to the mediation, because if you're going to be trying to do it during a mediation, it's too difficult and you're going to lose your negotiation power and the speed of getting things done. Additionally, I think you should start lien negotiations before your mediation if you can. For example, if you have ERISA liens or anything like that, you should be doing those talks early. So that way, when you're doing the mediation, you can have an honest conversation of what is the actual dollar amount that you truly think will go in the client's pocket. Also, again, this is having, like I said, having Traci beforehand to talk with the clients about, are you going to do a special needs trust? Do you do a structure? Do you have a blocked account? What are all the different types of ways of how you can place this money? Because it'll also let the client feel more secure when he or she is making that decision of, being willing to settle the case. During your mediation, I think it's a really good idea to bring a settlement agreement with you. So that way you can have something that can be signed right then and there. I just did a mediation not too long ago and I stupidly didn't do this. And I got really nervous afterwards because there was a lot of parties involved. And while you still have something that's signed, kind of the mediator does, I do think if you can just get something signed right then and there, it just makes everything so much smoother. Also, you need to talk about a confidentiality agreement. Are they going to all of a sudden, after you settle the case at mediation, then say, oh, by the way, we want a confidentiality agreement? Like, I don't think so. I mean, that's part of the bargain. So make sure stuff like that is being talked about during the mediation. Also, I tell the mediator at the very beginning of a mediation, look, my client might do a structure. I'm putting that out there right now. I don't want to hear it from the other side. If that's going to be an issue, we need to talk about it now, because I've had in the past where you settle the case and I say, okay, Traci's going to do my structure. And then it becomes an absolute cluster because they're like, no, we want to use our own person. And it just creates a nightmare. So I think these are all the things you need to have discussed at the beginning. Also, do you need board approval? When's the next board meeting? When's this going to happen? And get that as part of your settlement agreement. Because if they're going to tell you, okay, the next board meeting, for now is in January, then it's okay, this is going to be brought up at the January meeting. Payment is going to be made 30 days after that. Again, that should be part of the settlement because it just lights the fire. Otherwise, I've had it where they're like, oh, well, it wasn't heard at this board meeting. It'll be heard at the next one. And then the next one's 4 months later down the road. And what are you going to do? I mean, you unfortunately don't have much recourse at that point in time. So if you've got that done early in the actual settlement, it'll just make things so much smoother. And then you've got a piece of paper that you could always go into the judge or something like that if you need to, you know, to light a little fire, let's put it that way. And then also just, you know, a quick little thing, like a little plug I like to always say is the lien funds. If you haven't finished the negotiation of your lien, you are required to hold the full amount of the lien in your trust account. So when you go to start paying people out, do not drain the trust account based on what you assume that you're going to get the lien reduced to, anything like that. You should always keep the full amount in your trust account because if anything ever happens, you've got to pay that money and then it looks like you're tampering with funds. And as we all know, that's the first place for, you know, to get sanctioned or to be disbarred. So that's kind of my little like pre-settlement fund tips and tricks type things. But I think now Molly's going to dive into a little more about the actual, you know, how to do the minors comps. And I know she's going to discuss this, but make sure minors comps, as Tracy said, there's so many boxes to check. Just make sure you have someone come back and double check your work, even just to do the math, because there is absolutely nothing worse than to finally show up to that hearing and the court say, counsel, your math is wrong. And then now you've been pushed another 30, 45 days. Then the structure that was supposed to be funded now can't be funded. So that messes everything up. And it's like, you just sit there and pull your hair out, even though you're screaming, I'll just write it in. Like they won't let you do it. So, you know, I've done that before. I was like, I got a pen, like, let me just do it. And they're like, no. And I'm like, oh, so just make sure you have all that double checked beforehand. But clearly I've had too much coffee this morning. So with that, I'm gonna pick it up over to Molly.
Once they switched over to e-filing and Orange County started first, that completely changed everything. In LA, it was like, get the pen out. And we would actually take a copy when I would attend a hearing. I'd take my printer with me and we'd actually just go reprint a whole new one. But because everything is on e-file, you can no longer do that. Before we switch to slides, I want to make a couple comments on what Taylor was saying is bringing in a settlement planner if it's a case that does need planning, and or you have a client that has crazy expectations because instead of spending so much time even at the mediation, the expectations of if they know something, the two main things in every single relationship, professional or personal, is miscommunication and wrong expectations. And so if you can communicate on a detail level, and a lot of times it's the little details, even if you're attending a mediation, what do I wear? Some of those details. But when it comes to expectations, when I know I talk to a client in advance, when fleshing out whose money it is a little early in a very gentle way instead of right at the end really will help the mediation and or the settlement agreements and the finalization go better. But when you're breaking down to what their needs and wants, sometimes clients don't understand what, let's just say $1 million. What does $1 million mean? If you can break it down to, it'll pay off your debts, it'll take care of your immediate needs, it'll give you some additional income for the rest of your life. Setting that expectation up front is helpful. When you do the planning conversation in advance, it also fleshes out that settlement agreement that Taylor was talking about, because you'll know up front if you need to make sure that you don't sign the release at the mediation, you sign a stipulation to avoid any of the structured settlement. But if you know that a structured settlement is not needed at all, then get that agreement signed. Absolutely, right there, right then. A lot of people don't understand, I know you think, but a lot of people don't understand that settlement planners actually are no costs or no fees to the attorney. So utilize the resource. And your planner should also be doing that math. We find math all the time. So utilize, even it helps your your assistants and paralegals and, the people helping you, your staff sends over the petition and the order for a quick review on the outside. We catch a lot of things that aren't. So there's a lot of things that doing things in advance is definitely going to make the post settlement go much, much smoother. So just wanted to add on to a few comments there.
And before, because actually I think Traci's slides are next, but before we go to those, I wanted to jump in as well too. And I totally agree with everything that Taylor and Traci said. And I think expectation setting is just so important with people, and framing too about, Taylor was saying, well, this money isn't my money, I'm the parent, but in a sense it is, because, you're the parent, you're providing for this child until they're 18. And this money may not be available, if you're doing a structure or you're doing a blocked account, that may not be available to you today, but the money you're spending now, you're not going to have to spend that after this child is 18, because they're going to have an annuity payment every month, or they're going to have, whatever is set up. And so I think really framing the way that you're talking about the money and what it's being used for is helpful with the parents to understand that this is going to lift a burden off of their shoulders as well. That now that they have a child that has emotional issues or a physical disability because of an injury they sustained, that they're not going to have to worry. Most of people raise children till they're 18, and then, they push them out the door like my parents did and say, good luck to you. But when you have a child that has an emotional problem or a physical disability, you have to make peace with the fact that that child is now going to need you for a lot longer than you expected. And so this money that they're getting through this settlement, they're going to be able to have to help them from that age 18 on to make your life and their life a little bit easier. The other thing that I would highly encourage everyone to do, I believe it's the Diaz case. There's a new case that came out, I think last year, that we used to be able to just write in our settlement agreements, the court can retain jurisdiction over the settlement, forever. And that's under the Diaz case, that's no longer allowed. You actually have to have a stipulation signed by the parties, not the attorneys, that says we agree to have the court retain jurisdiction. So for those cases like Taylor was discussing, where you require board approval, I can't tell you the number of times I've been screwed by a county or a city that settled with me, and then 6 months later, we're no closer to receiving the funds. And I have an annuity funding deadline, and I lose my interest rate. So I think that it's really important to, because some defendants will also push you on getting a request for a dismissal filed or something like that, as a contingency of the settlement agreement. And I think it's really important to protect your right to go back into court to ask for them to enforce the settlement agreement. Or, in my case where I lost my annuity funding date, I had to go back in and file a whole new minors compromise because the numbers changed, because the amounts change. So I think it's really important to bring that with you to the mediation, because the parties have to sign it. And obviously we're living in a COVID world where nobody is probably physically going to a mediation, but that's still something you can circulate through the chat feature of a Zoom mediation and say, yes, we agree to this amount, but your client is clearly present because they're participating in this mediation. We need them to sign this before the day is over. So if anyone watching this needs a copy of that, we have one that we have in our office that's a standard form. I think most mediation companies have their own version of it as well, and I'd be happy to provide it. But I think that's a really important factor, especially if it's a government entity, or if you're going to be doing installment payments and they get 2 payments in and then just stop paying you, because you don't want to have to file a whole new lawsuit for breach of contract.
That's a great point too. And this was such a good slide, because it brings up a lot. One of the things that it's important for everybody to know is there's a probate code that there's parental duty of support. And that's a big, big deal. So when a parent wants, to utilize the money prior to the age of 18, there's a parental duty of support rule. That means that settlement funds cannot be used, even when we do a special needs trust, it cannot be used for haircuts or clothing or just typical things. You cannot use it. Braces are kind of on the fence sometimes. In tutoring, most of the time will be approved, but sometimes it just depends on the situation. Like a lot of Taylor's cases, those are the cases that need that additional help, and the judges will approve it. But there's a parental duty of support, and so that's important to know right up front when they think that there's funds that should be available to them to use for them to take care of them so that they can go to swimming class and stuff like that. Unfortunately, most courts won't approve those kinds of things because that was what you would do as a parent, whether there was a lawsuit or not. So I just wanted to throw that in when you're talking to clients about the parental duty of support rule.
I was able to, we did it, Tracy, I think, oh God, this was years ago, but where the girls wanted to join a like a competitive dance group or something like that traveled. And so it was something I think that was a little bit more than just kind of a basic thing. Like it was going to be quite expensive for, you know, for hotel costs and the fees and stuff like that. And the court approved that for us. And I'm sure, Tracy, you can speak to this, but I'm sure it all depends on who your judge is as well.
100%, 100%. For any of you filing out in Temecula, they now have a rule that the judge out there, actually, I apologize, I forgot his name, but he will not allow an annuity payment after the age of 18. He's totally good with a single lump sum at 18, but actually has taken the stand that no payments at any amount can go after the age of 18. So we, in my office, we have kind of a spreadsheet of who's doing what in different courts. So that's just something to be aware of. So exactly, Taylor, depends on who your judge is.
That's insane to me because the minors, I mean, we'll go through the minors comp forms, but like there's literally a section that anticipates a multiple year annuity after 18.
Absolutely. But yep, different views. In the state of Pennsylvania, any case, it is actually the rule across the entire state, any case over 25,000 goes into an annuity. So we have states that are 100% just like, hey, 25,000 or more, it has to be an annuity. Then we have judges like that. So what do you do?
Okay, well, I think you go to the next slide then.
Yeah, I wanted to bring up, there's the new forms for 2021 for the minors compromise and the dependent adult or an adult with a disability. So there's just a couple little tweaks on this form. They updated a few things that are highlighted, just are a little bit different, but the couple things I really, really wanted to point out is now this new section that if your adult with a disability is competent, they need to check this box. So under the claimant, if they have capacity, they check the box, and they do not have a conservatorship at this time, they check the box. These are super important, and you'll see later where they require their signature. I actually really like this. The reason I like it is because sometimes even though you have a disability, it doesn't mean that you're incompetent. And you can make some decisions, and that gives us a little bit of breathing room when I kind of do some creative planning. In the petition, when we're doing distributions, we actually can give money to a disabled adult. And I've done that a couple of times where we had a defendant that required us to get a compromise or have the compromise done or the hearing done. So the judge would approve the settlement because the lady was a major alcoholic. And so even though she wasn't legally incompetent, she just didn't make quite the best decisions. And thank goodness we did end up doing a trust on her, but we also gave her a significant amount of money in cash up front. And then there's other times where it just doesn't make sense. They're elderly and there's some power of attorney and such too. So there are circumstances where it does make sense to ask the judge to give the money to the disabled adult. Another great place is somebody that's moving out of the country. That because a lot of times when you're settling a case that's opened in California, you have to finalize it in California. However, they may be moving back to a different country, back to their family. And so this is an important thing to know, that you do need to check this box if it's a disabled adult that has capacity and they do not have a conservator. The next slide. And this is where the signature is on the petition. So I just wanted to make sure it's pointed out. So when you're going through it, just make sure. And you know, what's funny, I find a lot of times that sometimes you just got to take the petition and actually read everything. I think a lot of times we get in a hurry and just check the boxes, or we just get static, but every now and then you need to just read the petition. And then they're really pretty simple to go through. Next slide. And this is another new thing that is on the new forms, is they broke out the medical expenses just a little bit more. So you can see here the total expenses, all the payments that have already been made, what you need to do. Then, so they've separated this out a little bit more. So they really want the liens to be clear. So you're going to have to be more clear when you're breaking out these medical liens too. So this was something I just wanted to give you kind of a heads up on as well. And
This
next
is-
slide. Go ahead.
This is really interesting that they're asking for you to say, what the total amount of meds are and then what it's negotiated down to, which is, I don't know. I don't know how I feel about that, because we typically do try to negotiate our clients' liens down, but we don't normally share that number with the defense unless they require a check to be cut directly to whomever we've negotiated with. But that's an interesting, I wonder why that change was made.
Yeah, and it makes it a little more difficult to, often we will take a lien if we need to get a compromise on calendar, at least, because we all know that Medi-Cal is 120 days right now. And so a lot of times if we know the number and we know that it's something reasonable, we can settle the case. And we have had judges go ahead and approve with holding back that amount plus a little bit extra. So if there's a Medi-Cal lien of 150,000, sometimes we will hold back 250,000, and we have gotten approval on that. It's a little tricky, but having this breakdown makes it just a little bit more difficult. So I think they're doing that on purpose.
Interesting. Okay.
Yeah. And again, this is continuing. The court finds the claimant either consent is not required because they're a minor conservator or a person who lacks capacity, or they are. So again, this is on the order form. So just wanted to let you know, if you check the box, obviously on the petition, you need to make sure that the corresponding boxes are checked on the order.
Okay. So I'm going to kind of run through, for any person who's on here who has not filed a minor's compromise or understands what one is, what a minor's compromise is. So this is a petition that you must file if you have a minor client involved, and we're talking 17 and a half years old, that counts as a minor, or anyone who's disabled. And this is basically something that the court does so that they can supervise the settlement and make sure that the settlement is being done in the best interest of the child or the disabled person. Ensure that the settlement is fair and equitable, and that the person receives their settlement funds whenever they're able to, whether they become an adult or whether it's going to be managed if they're a disabled person who's not able to manage it themselves. So it seems like a much more complicated thing than it actually is. I think the first time I did one, I wanted to kill myself, because it was just like, the forms are so confusing, and you have to, truly, if you do it well, you have to attach a lot of documentation, and they take a long time. So, but once you do a few of them, you really get the hang of it. They truly are not as complicated as they seem, and they're much less daunting. And you just file a petition with the court, and then typically in non-COVID times, you would then appear for a hearing with your client, their either parent, guardian, whoever is involved, and then you would have a hearing on it. And the level of the hearing, the depth that a judge may go into it depends on the judge and depends on your case. So if I had a case where we settled a minor's case for a minimal amount of money because they were not the main plaintiff, and we were not taking a fee on the case. And the judge looked through everyone's paperwork who was in line that day and called me first and said, if you ever have a minor's comp where you're not taking a fee, please just tell my clerk and you don't even have to show up. So, it really depends on the judge. It depends on how complicated your case is and what you're, and Traci can talk more about what you're doing with the money, because certain things are a little bit more standard than others. But you show up to court, and now in COVID times, every jurisdiction is handling it differently. I know Los Angeles Superior Court at least is allowing petitions to be heard without the guardian or the minor there, or to just be available by phone to answer questions if the judge has them. So it's really important, if you have a case that you've settled with a minor, that you call the clerk for the department that you're in and find out how the judge is handling minors' compromises. And I think there is a little bit of a misconception about minors' compromises, and Traci can go in. We're going to talk more about how to deal with this situation, but there is some sort of belief, I think, amongst the plaintiffs bar specifically, that a minor's compromise is not required for settlements less than $5,000, and that's not true. You have to have a minor's compromise for every single settlement, regardless of amount. And, there's ways to deal with the cost associated with it. And we can talk about that when I get to the next slide, but it is required, because if you don't do it, the guardian can void it later. The guardian can wait 2 years and say, you know what, I don't agree with the settlement. We're going to sue this defendant again right before the statute of limitations expires. So that's why most defendants require them as a condition of settlement. I think a lot of times people think that defendants are just being difficult, but it really is to protect their interests, and it's to protect the minor as well. So there are 2 types of minors compromises that you can do currently, and one is an expedited and a non-expedited. And so expedited petitions are for claims that are less than $50,000, and this means $50,000 total paid to all parties. So if it's a person vehicle collision or something, you have to consider the total amount. And then the other situation where you could do an expedite is where the total amount payable is the policy limits of all liability insurance policies covering all of the contributing parties. So there are some rules to this. You cannot do it in a wrongful death case. It does allow the petition to be heard and approved by the court within 35 days. And typically you don't need a hearing. If you want one with an expedited petition, you can request it, but they're not required. A court can approve them without a hearing. And the form that you use is called MC 350EX. And it's pretty similar to the regular petition. It's just specially created so that the court knows that it's an expedited petition and that they have to hear it within that 35-day window. I have heard, everything I've heard is that the expedited petitions are still being granted in a timely fashion, that there isn't a huge COVID delay because of these. Obviously there are exceptions, but I've heard that they're still being approved within that 35-day limit.
And it's important to know that those are the ones, not that you don't want to extra check your math and everything on all of them, but that you really want to. And then if you have a court that you can go online, Orange County is fabulous with their probate notes. As soon as you file it, we start checking just 2 weeks after. 2 weeks after, we're always online once a week or a couple times a week, just to see if there's any updated probate notes so that you can fix them or correct them. Do not wait for 5 weeks and then wonder where it is, where the approval is. Make sure you're looking, if it's a court where you can go online and check the probate notes, definitely remember to do that. Put it on calendar.
And I think that goes for regular too as well. Like once you file something, because these are so complicated, it can't hurt to call the court and just say, hey, I filed this, like, is there any issues? Sometimes the clerks will tell you like, oh, you messed up your math, so we're going to reject it. Or, oh, you forgot to attach this attachment. So, and I really do think that's, Traci touched on this. When we do them in our office, we work with Traci very often, and her office reviews everything we file before we file it. And then, I typically have a paralegal start it, and then I do it. And then I have another attorney on the file look at it, because if we can just get it done in one shot, it's so much simpler because of annuity funding deadlines, because of whatever. And so I think if you can have as many people look at it as possible. I mean, if you're a lawyer on here and you want me to look at your petition, I'm happy to do so. Like our emails are going to be at the end. Feel free to send me what you have, but it's really, I think it just saves you so much heartache if you can have the settlement planner that you're working with involved to make sure that everything's done right, and then call the court once it's filed and just check on it, be the squeaky wheel. And like Traci said, utilize these tools that the courts have available for you to check on that stuff. This is kind of, and I'll let Traci talk about, was this your slide or was this mine?
It's both of ours. Go for it.
But this for those scenarios, because we know there are a lot of cases where you're settling a minor's claim for less than $5,000. And so, these settlements are still required to have a minor's compromise. And so there are a couple of different options that you can utilize. And I think that it's also important to it depends on how you want to play it. If you're a plaintiff's lawyer and the defense is saying, yeah, we settled this case for $4,500 and we require a minor's compromise. If this is like a pre-litigation case, say, well, okay, we would like the defense to pay the filing fee. You can try to negotiate that way so that you're not incurring, a $500 or however many dollar cost to file the lawsuit. If you haven't filed one yet, if you're filing a probate or if you're going to file a civil case. They do also have fee waivers as well that you can apply for depending on the status of your plaintiff, to try to avoid incurring that big cost and cutting into the recovery for the client. Okay. Okay, so guardian ad litem. So this typically applies to cases where you have filed a civil lawsuit. So this is a case that's already in litigation, or it's going to be in litigation. In my office, we typically file the application for guardian ad litem at the same time that we file the complaint. So it's in the system, it's already been approved. These are typically approved without a hearing. I don't think I've ever had one challenged. I think our office has challenged one once on behalf of someone else, but I don't think that I've ever had one challenged. And a guardian ad litem is just somebody who is acting, the court has approved as acting in the best interest of the minor, of the disabled person. It's this form CIV 010. It's a very simple form. You just file it with the court. And you should really think about, the people in your client's life that would be the best fit for it. I've had cases where the guardian ad litem has not been the parents. I've had cases where it's been, we've had to make a tough choice between one parent or the other. I've had cases where both parents have been a guardian ad litem. So you really should have a conversation with the people involved in the case on behalf of the minor to figure out who is going to be the best fit, who's going to be available to come with you to the minor's compromise hearing. If you have a client whose parents live in another country, you might want to find a family member in the United States that's going to be available to you and able to attend hearings with you, so that they can be an active participant in the process.
And while you're there, so one of the things that's important on that slide too is that getting ahead of it, when you said that you file your complaint, I want to make sure that everybody that's viewing this knows that when you file your complaint, actually have the petition in mind. And the reason I say that is the taxability of a case too. Sometimes we call them some gray cases, I guess, but certain cases you need to have physical injury for it to be income tax free. And because the emotional distress, not on account of physical injury, is actually a taxable case. So be careful of how you're filing the case. And even when you just use harassment, is there a physical, can you put battery, can you put assault, can you put anything that's filed in that original complaint? Because if I don't have that, and a lot of times it's something that happened on a playground and failure to supervise. Generally, we can work through those, but failure to supervise, for all intents and purposes, as you can see, is kind of a gray area because there was no physical at that point in time. So super important when you file in advance, thinking far. With that said, also in regards to the guardian ad litem, remember that when you're filing the guardian ad litem, because maybe they're in a coma still or in really bad shape, remember who your guardian ad litem is and how that affects the long term, because now you settle a case 3 years later and they're actually doing really, really well, and they become incredibly frustrated that there's now going to be ongoing court supervision. So when you have a guardian ad litem on the case, just remember that somebody else is going to be controlling that at the end. And so either you need to start preparing the doctor's records or something to remove the guardian ad litem if your adult is now competent and can make their own decisions, or we need to make sure that that guardian ad litem is a good person that can make good long-term decisions as to whether there's going to be a structured settlement or whether there's going to be a minor's trust or a special needs trust or a settlement preservation trust. So it's super important, as Molly indicated, of who your guardian ad litem is.
And I think too, as an attorney, touching on something that Traci said as well, the taxability of settlement proceeds is a tricky area, and I am not a tax attorney. And that, I think that's something that's important to express to your clients from the get-go, is that, and it depends on your client. Like, I work with a lot of personal injury, wrongful death clients who are not people familiar with tax law. So they don't ever ask me, what are the tax consequences? And we have other cases with, doctors and professors. And that's like their first question is, if I get a settlement, how is this going to affect my taxes? And so I think it's important to, express what you understand generally about the law, but make sure they understand that you're not a tax attorney, that if they have specific questions about the taxability of anything they were to receive, that they should consult with a tax attorney, who specializes in that. Certainly someone like Traci can give them advice as well. But I think, if there's any question that it's going to really complicate things for them, they should really consult with someone who is more of an expert in that area. But I totally agree with what she said about, making your complaint and keeping the options as broad and open for your client as possible, so that you can take advantage of the non-taxability of a personal injury type case, if you can, because that is a huge, huge advantage that clients that have something that resulting from a physical injury are able to take advantage of.
A big deal. So super important to pay attention to how your complaint is written. Definitely as open as possible.
Yeah. And so I think moving on to this next slide, it's really important, again, to get a financial planner and a settlement planner involved as soon as possible, as soon as you sort of think that this case might be heading towards settlement, so you can start discussing the different options that you have with the money. These are just sort of very general. I know there's a lot more specific ways that you can handle the money, but these are sort of general ways that you can handle different settlements. And again, it's really specific to your client. It's specific, are they on government benefits? What is their disability? What is their injury? What is their family like? What type of person are they? We have certain clients that an annuity really is the best bet for them, because they need just a little bit of money at a time. If we gave them $200,000 at age 18, they'd buy 16 Hummers, whereas we have other clients who are old souls and they know that they want to go to Harvard and that's going to cost X amount of money. So you really do need to work with someone. And this is why I love working with Traci, is because she takes such a specific and individualized approach to every client, and there's not a one size fits all. And so these are kind of some of the options that you'll find on the minors compromise form. You can do a blocked account, which is just an account and the minor gets the money when they turn 18. You can purchase an annuity, and that can be completely customized. You can do partial annuities with some of the money and blocked account, or you can do a lot of different things with that. There's special needs trust, there's minors trust, there's all these different ways that you can utilize it. And to be honest, yeah, as a lawyer who's practiced 10 years, I still don't even understand all of these. So I think that's why it's important to have someone who has expertise in this. And like Traci said, this costs you nothing as a lawyer. It's like, I don't understand how that works, but I'm willing to take advantage of it. But it costs you nothing to have somebody in the room that clearly understands each of these options and how to get it successfully approved by the court.
Yeah, and that's a good spot there. So Molly, a couple things, just so everybody knows, is the reason that there's no fees or costs is when a structured settlement person, if we're doing a structured settlement, the representative represents 9 different annuity carriers like USAA, Berkshire Hathaway, New York Life, MetLife, Prudential, Mutual of Omaha, very large, safe companies. So we are brokers, if you will, for those different carriers. When there's a structured settlement placed, then the funds, we are compensated by the annuity carriers. So and it's super, super important to have your own representation. I know that Taylor and Molly know this very well, that when the defense says, no, you need to use our broker, you always want, because I'll tell you that the brokers work together, kind of like a real estate transaction. You want your own representation. Yes, buying a house, there can be one real estate person representing both. However, you got to look at the fiduciary obligation of that person brought in. And so you don't want to use the defense's broker with that. So they're compensated through the carriers. One of the reasons that I'm a financial advisor is because if a structured settlement, I strongly feel it's a conflict of interest if my only product is a structured settlement. So because I'm a financial advisor, I can be compensated post-settlement with, settlement funds if I'm the chosen advisor. So that's how that there's no fees or costs to the client and or to the attorneys. This was a good slide to also point out a couple things. If you just remember this, it's going to be so helpful, is that a minor cannot own an investment. And that is across the country. So that's not California. That's not our current judges. That's not something that you say or I say. A minor cannot own an investment. The only thing they can have is they can have a blocked savings account and they can have a structured settlement annuity, because both of those products are in their name. Even when you talk about a guardianship or conservatorship or an UPMA account, those accounts are for the benefit of but they are actually not fully in the minor's name. And so actually, even though there is probate code that says anything under 20,000 should not require ongoing court supervision, I'll tell you, probably 90% of them do. So even though there's codes, the judges are still not comfortable giving, $19,000 even to a parent in that kind of account. So because a minor cannot own an investment account, you really are down to two choices if there's no special needs involved. Taylor does this often. What she indicated at the beginning was she does a combination. So we might use a structured settlement for the majority, but if there is a need, some tutoring, or there are some future medicals or a plastic surgery or something like that, the client can petition the court. It is $65 each time they petition the court, and they can pull money out of that for the needs that they have. So if there are needs, do a blocked account and potentially a structured settlement with it combined. Another note is that I think a lot of times when the parent says they want him to have the money at 18, the immediate default is a blocked account. However, I don't know about you guys or where you're banking, but it's like nothing, 0.001. So if the minor is under the age of 13, sometimes, or under the age of 14, a single lump sum structured settlement annuity is going to pay more than a blocked account. And sometimes it's a little less work on the setting up the account and with the attorney as well. So those are a couple tips while we're on this slide that I wanted to make sure that we brought up.
Well, and
Go ahead.
I was going to say, I was just going to jump in on that too, because the blocked account thing, while it sounds conceptually super easy to do, I cannot tell you how many times I've been on the phone with a banker because my client says, well, I bank at this bank. This is where I'd like to do it. And the people are just like, yeah, we have no idea what you're talking about. It's not something that they really deal with. And so it's actually not super easy. So even just being able to do that annuity, as Traci said, just is actually easier. So if you're able to do that, but if they need access to the funds, that's a little bit different. The other thing too, which I think is super important to know, if you're doing a structure, you as the attorney cannot take those funds. Meaning, so like if like the defense, like, okay, like I'm going to shoot you a check, you deposit it into your client trust account, and then you as the attorney pay the structure, you absolutely cannot do that. That's why if you're making these structure choices, this is why you need to have these conversations super early on and not at the last minute, because all this language has to go into the settlement agreement and the defense has to write the check to the structure company. So it's really important that, this is all done at the beginning. So that's a really important thing. And then the other thing I wanted to address, which I thought was something that I actually didn't know, and recently Traci was explaining to me in one of my clients' cases where she's the client, well, the one who was injured, she's a disabled adult, but she's massively mentally and physically disabled. Like she cannot make any decisions on her own, but she gets, like they get government assistance, and that's how like she's able to do her programs and get, the treatment that she needs. So it's really important that no matter what kind of funds we get for her, like she doesn't want to lose those government benefits because she's set up and everything. And so that's why then the special needs trust becomes so important. Mm-hmm. And I think Traci did a really good job in explaining to the client, and maybe can give just a quick overview, that the special needs trust sounds like it's this money that goes in this weird place. And a lot of us think that you have to then like, okay, if I want to buy my daughter diapers, because she needs them, or if I need to buy her, whatever it is, clothes or whatever it is that she needs, I have to call up, Johnny in some random office somewhere and get his approval for everything. And it's way simpler. And so I think Traci, like, if you don't mind doing a
special needs trust, I think that I think some people, they think it's scary and hard to do. That's only true if you don't have the right people doing it. So trying to do it cheap, trying to do it on your own, not doing it with people who do it every day. And because I'm not an attorney, I can't write the trust. It's super important that we have specific trust attorneys that do special needs trusts. If they're written right and you have also the right trustee, because a trustee could be a parent or a trusted family member, not advisable, but it can be. It could be a private fiduciary or it can be a corporate trustee. So generally the funds, as long as it's for the sole benefit of that injured person, that or the disabled adult, that's pretty much, you can do everything. So there's nothing you can't spend money on. Now, with that said, can you buy a house? Yes. Can you buy a car? Yes. Can you pay for caregiving? Can you pay for vacations and trips and dog food, cat food? Can you pay for, you actually can pay for everything out of a special needs trust. The limitations are, do we have enough money? And that's one of the things is, can you buy a house? You can, but you can't if you don't have enough money. Can you go on a vacation? You can, but you can't if you don't have enough money. So the court is always going to look at what is called a depletion analysis. So once a year, I do a depletion analysis for our clients and say, at this current spending rate, is the money going to last? And that's what they're looking at. So everything can be purchased. It just depends if we have the financial means for it. Also, traditionally, things that are typical and normal, so, diapers, therapies, tutoring, gas, insurance for a vehicle, those kind of things, those are just daily, regular, routine expenses. Those do not need immediate court supervision. Court supervision is on, we're spending, $5,000 for a new bed, we're buying a new vehicle, we are doing attendant care. So things that are large ticket items will require court supervision or court approval on. And so really it's having a plan up front, kind of what we said the first time when it came to the minors compromises. The more you cross your T's, dot your I's, and the judges get to know you and they know that your product is really good, they're going to build trust and they're going to know that when you're putting a plan together, it's a solid plan. But I would say 100% of the time I can achieve their goals if I have enough money and I can make it work. You just got to have those conversations with the client. And I'm not going to tell you that they're 45-minute conversations one time. It's multiple conversations of getting to know your clients and spending a lot of time with them that attorneys don't do. So again, bringing the right planner in and putting the right settlement team will make your cases go so much faster.
Totally.
I was just gonna say the other thing too that I've done, I had it on a case where if you have a minor who, they're 16, 17 years old and they kind of have these goals in life, I've sometimes seen those, I don't know what you call them these days, like the helicopter parents, where they're putting their opinion and like the client's not getting listened to of like what they want. And now obviously if the client said, I want to buy a Range Rover, it's like, okay, this is not what, we're doing here. But, I've had where there's kind of been pressure of, okay, well now you're going to pay for your younger sister's, education or something like that. I think it's important that the attorney listens to what everyone's saying. And I've had situations too, where I've pulled the parents out of the meeting and said that it's really important for Traci just to sit and meet with the actual like high schooler, just so that Traci can listen to what their needs and wants are. And then when bring the parents back in, then Traci can massage it all of like, well, I think this is how it should be, So yeah. So I just think it's, just to make sure that, the person who's actually being injured is being heard as well. Because they're really your client. So just keep that in mind.
Very, very important, because if we put a plan together for a minor and we can communicate with them, with that minor, if they have that ability to do that, if they put the plan together, they're less apt to try to make adjustments or changes to it later and be frustrated later. So I think that's a fantastic point, Taylor.
And I think it even comes into play too. Like Traci and I did a case, I lost all track of time, I think it was last year, where we had two older women, probably in their 60s. And I feel like it took us time to massage them into the idea of understanding like what they could do with this money. It was probably the most money they'd ever got in their lives. And, it took some time to get them to understand like, okay, what do you want to do? What do you want to do in a responsible way that still leaves you money to take care of yourselves? Because they had, horrific injuries. And so like having those conversations and talking about it in the way that Traci talks about it with her buckets of, what do we need to pay now versus what do we want to save for later, I think is really important, because people don't think about this stuff. Like nobody thinks about like, well, okay, I'm going to get hit by a car and then I'm going to get $500,000. What am I going to do with that money? Like nobody thinks about that. And certainly not 16-year-olds. Like they don't think about that. So you have to have those conversations, and the sooner you can have them, like Taylor and Traci are saying, the better, so that your client is not blindsided the week before mediation, having to make these like long-term decisions about their financial future.
Definitely getting the money in your trust account faster is all about pre-planning.
Yeah. So just some quick things, some tips and tricks for getting these minors compromise moved through quickly, even during COVID delays. So you have two kind of options for where you can file it. If you have a civil case pending, you can file it in the probate court. And you don't have to have a guardian ad litem. A parent can file that. If you have a civil case pending, you have to file it in the department where that civil case is pending, and you have to have it filed by a guardian ad litem. Some lawyers I know who don't have a civil case pending will actually file a civil lawsuit because they don't want to deal with probate. But I think, again, this is where talking to someone like Traci makes sense, because if you haven't filed a lawsuit yet, you can talk about whether she thinks that jurisdiction's probate department is going to be better than filing a civil lawsuit. And so I think it's really about strategy in terms of getting this money to you as fast as possible, because, I think a lot of us, we are so focused on the end goal of resolving the case that we don't think about what happens after we've agreed on a number. And as Taylor has pointed out, if you have a case against a government entity, it could be 6 months, it could be a year till you get that money. And if you have a client that has immediate needs that, needs something, it's really important that you start thinking proactively about, how do I make this process go faster? I try to reserve a minors comp hearing date like the day after we've settled the case, even if I know it's going to take me some time to get it done. I'll set it, I'll just reserve the date, because we all know hearing dates are few and far between. So start talking about that early on. These are sort of just the documents that you need to file depending on what you're doing with the money. And, you would obviously do the expedited petition if you're going to do an expedited application. And then these forms at the bottom, MC 355 and 356 are, for if you're doing a blocked account. And you really want to, again, have Traci or whoever you're working with look through all of these forms once you filled them out before you file them, to make sure that, all those T's are crossed. So here are sort of my tips for getting approved the first time and not having to redo it. Like I just said, start early as you can. You have to do one petition per plaintiff. So you can't, if you have 3 children, you can't just do one petition for all 3 of them. You need to fill out every portion of the application. That doesn't mean every section will, the section that deals with what's happening with the money, you don't need to check every box. You're only going to check the box that, applies for how the money is being handled. But make sure you read every section, because you will have to check some sort of box, I think, in almost every single one. If it's a personal injury case, you need to get together the most important medical documents. So the petition actually asks you for, doctor's reports, operative reports, and then asks for prognosis. And so, in a lot of my cases, I don't have a report from a doctor that says my client is going to need X amount of dollars in the future. Sometimes I do. Sometimes I have a life care plan, but if it's, a smaller case where their injury has kind of resolved, they might have some lingering residuals. I don't have that. So I'll actually just put a portion of my attorney declaration, which we'll get to in a second, and I'll address, this client has been seen by these doctors. This is my understanding of what their injuries are, and, their prognosis is good or whatever. So you can kind of put that in there. And I haven't had a judge be like, well, you don't have a report about prognosis, so I'm not approving this. So you just want to show the judge that you've done as much research and presented as much evidence as you can about this minor, and, are they going to need thousands of dollars of future care, or are they kind of, the best they're going to be? And this money could be maybe money for education later down the line or something. Have your office put together a breakdown of costs. I think that's really helpful to attach. Sometimes I know some attorneys don't attach an itemization of costs, but we always do, just to be fully transparent with the court. Make sure you have a signed copy of your retainer agreement. Some lawyers will have the client sign the retainer and then they will not sign it. So make sure that you have a fully executed retainer agreement that you can file with the court. As Taylor said, you need all your liens finalized. So make sure you've started reaching out to Medicare or Medi-Cal as soon as that settlement has been reached or before. Check your math. And if you're me, have someone else check your math because I hate math and I'm terrible at it. And then prepare for the hearing. If you are in a jurisdiction or a courtroom where the judge is going to require the guardian or the minor to be there, have a meeting with them. And even if it's just going to be over Zoom, have a meeting with them, explain what the process is. In almost every single one of my hearings, the judge has asked the minor, and some of my clients have been as young as 3 questions. So you want them to be comfortable, understand there's going to be this person, they're going to be wearing a black robe, they're going to be sitting up on this thing, and they're going to ask you, about the car accident you were in, and they're going to ask you about your arm and how does your arm feel. So you really want to meet with the client and the child and make sure that they're prepared and that they're not, that they have answers to the questions that the judge is going to ask.
Especially the question of attorney fees and such
Mm-hmm.
too, is so you just make sure that they have everything out, especially if you think that it's going to come up. It just depends randomly. We all know that 40% is being approved often and well-deserved, but a lot of judges will kind of cut that back. And so they will ask the client, do you want to pay it? And as long as the plaintiff or the guardian ad litem is comfortable with it, then usually they'll go ahead and approve it. So it's good to have that awkwardness out of the way. And if they have any questions, sometimes I'll ask the questions if I'm attending too, just to kind of get that awkwardness out. And then we know right up front. So hopefully that goes smoothly. There's nothing worse than the client asking in front of a courtroom of a bunch of people and not saying, oh, now I have some questions. So you definitely want to get that handled.
100%. Before we go on to this part, I did want to touch on attorney's fees because that is the thing that I do see like on the listservs, what newer lawyers are posting about the most, like, hey, I got this great settlement and my retainer is for 40%. Do you think I'll get it? There is a case, and I can't find it here in my notes, but I can send it to anyone. I believe there's a case, or it might be a California rule of court that does not allow judges to have local rules about attorney's fees. So some judges in some jurisdictions have said, I won't grant a fee request more than 25%. And that's not allowed. There is a list of factors in I think it's California rule of court rule. It's like 7.95 or something, 955. And that has the list of factors that a judge is to consider when considering your request for attorney's fees. So you should do a fairly lengthy declaration that you attach to the application and explains why you think you deserve the 40%, because you were pursuing a novel area of law, because you're pursuing a difficult defendant, because of the nature and extent of the injuries that you had to work up, and you're essentially defending your work. But we have one that I've sort of recycled over the years, and I've never had a judge have a problem with it. It's been granted in every single instance. I think I've shared it on the Cala listserv, but I'd be happy to, share it with anyone on here. And you just explain why the 40% is, or whatever you're asking for, 33% is worth it. And, they may ask you questions about that. So you want to be prepared at the hearing to answer questions about that, but they can't just, apparently, according to Traci, some judges just do make rules, but they're not allowed to just say, we don't approve anything more than 25%. I mean, you can take a writ on that. So if you feel that it's warranted, but our office regularly has whatever our retainer, and our retainers vary depending on the case, but we regularly have our retainer agreements, fee structures approved. So.
Yeah, that's great. And it's super important. I think the 2 things, Molly, you mentioned the cost breakdown and the attorney fee declaration are usually the top 2, that when there's a rejection that they have missed documents for some reason, those are the 2 things that they want that are not filed. So super important to have. And for the attendees, I just have just a couple of quick slides. I just wanted to bring this out. A lot of people are unaware, and actually just this last year, they came out with non-US citizens, but I'm also going to go ahead and throw in people that cannot get a bank account for whatever reason, and they just can't do bank accounts. For non-US citizens, we do have other options. So you can do a structured settlement, especially just even in this last year, a lot of the banks that used to set up accounts for non-citizens are limiting those. And so when you're settling a case and they're not a US citizen and cannot open a bank account to receive the check or the settlement funds, there are a couple different options. One is there's a checking account. MetaBank is one of the banks. It's the same bank that did the stimulus checks for the government this last year during COVID. And so these are large banks that will actually open a debit card. So some will do a checking account and a debit card. Others will just do just the debit card only. But now you can put the structured settlement onto the debit card. So if you have a monthly payment stream, so you're not a citizen and or you just can't have a bank account. So this does work for US citizens that just don't have a bank account. And the monthly checks for the annuity can actually go on to the debit card. So that's kind of something newer this last year that a lot of people just don't know as an option. So also if you're settling a case for somebody that's like out of state and or out of the country, and this is a big deal if you're out of the country, so you have the ability to do that too. It costs either, it depends on what you do. Some of them have no setup fees, hardly any fees at all, and then others may require like $1,000 setup fee. So if somebody lives in, let's say Mexico, and they want to have an investment account, but you cannot have an investment account if you're not a US citizen. Well, let me say you're not legally you're not legal in the United States, you cannot open an investment account. So that gets tricky too. But so we have the ability to kind of open a trust account for them for $1,000 fee. Then we can actually do the wire transfers then too. So the annuity companies and investments can go into that account and then they can get wired and sent to a different country. I think there's one more slide on this that we'll go through. But ultimately, for any client that is either not a US citizen, going to move out of the country and doesn't have a bank account here, and or just somebody who just can't have a bank account. So I wanted to bring that up. And I think there was one more slide that I wanted to talk about is the ABLE account. This account is really made for any settlement. You get that pesky settlement, the client's on benefits. They can't spend down the money, but it's less than $15,000. I just want people to also be aware, ABLE accounts have been around for many, many years, but it is another tool. And again, you do need to be under 26 when the disability happened, and the amount going into the account is $15,000 or less. But it does keep your client eligible for their benefits, so they're not losing their benefits, and it gives them complete flexibility too. So this was something that a lot of clients don't even know exists. So again, there are a lot of different settlement options, and I'm gonna guess that in law school there wasn't a class for settlement options to go through it. And so, and don't feel that you have to know them. You just have to have a good relationship with somebody that does more than just structured settlements, but that can talk about all of these different options. And the last slide is probably my favorite slide, which is the one that Taylor had brought up earlier that just talks about make sure that if you think there's going to be a structured settlement, or if you have not had the opportunity to talk to your client again, is make sure that you stop, and whether it's in the mediation stipulation, whether it's in your email or any kind of correspondence that you're going to accept a settlement, make sure that it's contingent to the plaintiff or plaintiff attorney reserve the right, because yes, attorneys can structure their fees to lower their tax burden as well. They reserve the right to do a structured settlement. And Molly said earlier too, you think because it's normal and we do structures all the time that you aren't going to have a problem, but you do. I settled a case, or I didn't settle it, the attorney settled it, but the case resolved when we were at mediation. We were at 3 million, we settled it for 5 million, and it was a Travelers, and Travelers does structures all day long, but the adjuster was so upset that after it was settled for 5 million, we did the planning, we had everything set up, started to talk about the annuity, and the adjuster said, too bad, so sad, I'm not going to. If you wanted a structure, you should have done it, settled your case at the day of mediation. So sometimes they just have attitude, and there's literally nothing you can do. If there's no court involvement, you cannot get a judge to force the defendant to do a structured settlement. You just can't. I've testified actually in federal court on that topic, and you just can't do it. So super, super, super important to make sure you reserve the right to do a structured settlement, or don't sign that final release as well. So I think that this kind of comes to the end of our thing here and our seminar. And so I really want to thank Molly and Taylor for joining me in this. Is there Taylor, any last comments?
No, I mean, I think this is pretty in depth, and we covered everything pretty well. So hopefully this helps everyone.
Fantastic. Molly?
Yeah, I mean, I just think moral of the story is get started thinking about what you're going to do with the money and what the client wants to do as soon as possible, because there's just so many steps you have to take after you finally agree on that number.
Wonderful. Thank you both for joining me. Thank you for the viewers watching, and happy holidays. Thank you all.
Bye.